all of you. Hello, everybody. We're just getting started here. Welcome. We're very excited that you all could attend. I have two of my favorite people here with me today that are going to be presenting Ladybird Deeds and Probate Estates. I have Rick Linnell, who's a graduate of the University of Michigan and Wayne State Law School. He's been an attorney in the private practice for 23 years. He specializes in real estate law, short sales, foreclosure, and other forms of loss mitigation. And we have Bunny Lieberman. She has more than 25 years of experience working in litigation, probate, and real estate. She's an affiliate member of the Birmingham Bloomfield Women's Council of Realtors, and I know they are both very involved in that organization. I'm very proud to announce both of them, and with that, I'm going to go ahead and let them get started. Bunny and Rick, thank you so much for being here today.
Thank you, Chris. We're glad to be here. One question I forgot to ask you, Chris, is are we entertaining questions in the, I believe it's the chat bar or chat function?
If you have questions in the middle of the program, feel free to put them in the chat bar, or you can save it till the end. We're going to have 5 or 10 minutes at the very end if anybody wants to speak up and ask questions live at the end of the program. Thank you, Rick.
Perfect. All right. So let's start with Ladybird Deeds. Forgot to turn my light on. Let's start with Ladybird Deeds. What is a Ladybird deed? It is a form of deed, and it is a deed that's used specifically for estate planning. In fact, you may hear the term will substitute, meaning a substitute for a will or some other form of estate planning. And we can talk about that as the discussion progresses. But it's a deed that is used for estate planning when you know whom you would like to receive your property, but of course you don't want to give them this property yet. It's known as an enhanced life estate deed, but Ladybird is the common term you will hear. An enhanced life estate deed is different from a life estate deed. What's notable about a Ladybird deed is that it reserves a life estate for the current owner. And I'm going to circle back and say it in more plain English. But it reserves a life estate for the current owner, and the current owner will then name remainder men, which are kind of like beneficiaries. And that is the same that occurs in a life estate deed or life estate deed. The difference in an enhanced life estate deed is that the owner never gives up their actual rights in the property. The remainder interest is contingent. So now let me say that in plain English. I own a property. I have children. I want my children to get my property if I'm not here. But until that happens, which hopefully that's many years from now, I want to retain control of my property. By signing or entering into a Ladybird deed, I retain the current ownership of the property and all the rights that ownership affords me, including the right to sell, the right to mortgage, the right to lease, all the rights that are associated with ownership. But if I don't make it home tonight, my children will get my property without going to probate. And that's the significant part. We see in many instances, people will try to avoid using estate planning documents, whether they're concerned about the cost or they're just a little intimidated by the process, and they will use other methods to try and avoid probate, but not typically a Ladybird deed because they're unfamiliar with it. And the Ladybird deed, you know, it's not a panacea. It's not, this is the answer to everything. But in many instances, it is the answer to estate planning concerns. If we switch to the next page, I think I may have already covered some of this, but, well, is that the next page? No, oh wait, I think there was one. Go back one page, please. All right, I'll just go. What's important to know is that oftentimes people will use other forms of deeds, and I'm going to get into what's on the screen in a moment. Is oftentimes people will use other forms of deeds, as I said, to effectuate their estate planning desires. Said plainly, I want my kids to get it, my grandkids to get it, my church to get it, my alma mater, the Boy Scouts, whatever. I want them to get it. And they'll use a deed that can effectuate their desires, but it can also have unintended consequences. And the Ladybird deed, as a general rule, does not have unintended consequences. And again, most notably, it's because when you're the owner of the property and you sign this Ladybird deed, you're deeding it to yourself or life estate, so you still retain present ownership. But again, whomever you want, whether it's one person, many persons, an organization, whomever you want, they will get the property when you're no longer here. But in the meantime, if you decide to sell it, as I said, rent it, mortgage it, etc., you get to do those things. What's also important to know is that that remainderment interest, that can change. So, and this, I say this jokingly, but I have 5 children. That's unfortunately not a joke, that's true. But if I decide that I like one child today and tomorrow I don't like that child as much and I want them to be removed as the person that gets my property, I can change it every day, any day I want to. Now, I'm not suggesting that that's a wise thing to do, but what is clear, or what I want to make clear, is that the homeowner retains all of those rights. They're not giving up any rights at the time they enter into the Ladybird deed. There's no uncapping of taxes. There's no step up in basis. There's nothing negative that comes from a Ladybird deed. It is only positives, with assuming, again, that the Ladybird deed meets your requirements for estate planning. And we're not having an estate planning discussion, but there are people that have other assets, unique situations where second marriage, stepchildren, half siblings, etc. So it doesn't mean it's the solution for every issue, but as a general proposition, there are no negatives. And certainly if you talk to an attorney and you talk about your situation and they say Ladybird deed, assuming they know what they're talking about, there are no negatives associated with it. I think that as part of the discussion, it's necessary to talk about the different forms of ownership. So now we can go to the next slide.
Rick, we do have one quick question.
Yes.
Does a Ladybird deed have to be for an individual property, or can one be created for a portfolio of more than one property, such as a primary residence and vacation home or cottage?
So a Ladybird deed is specific to the property. And when there are multiple properties, what generally will make sense, and I want to be clear, generally, because you should always speak to your estate planning attorney. We do that work, but there are many others. When there's more than one property, oftentimes a revocable or living trust, which are really kind of interchangeable terms, would be used as opposed to various deeds. It becomes easier to manage, and quite honestly, depending on the scenario, it's probably cheaper too. A Ladybird deed is specific to a property. It cannot be used as a general catch-all to a group of properties, for instance. We want to go to the various forms of ownership. I think it's the next slide. So let me make a prefatory statement. When you as a property owner, if you enter into a Ladybird deed, you can determine the form of ownership that the remainderman will take the property by. Now, if it's one person, of course, it's not relevant. But if it's more than one person, 2 children, 3 grandchildren, your church and your knitting circle, I'm just picking things, then the form of ownership is relevant. And I think this is also a good time to talk about some of the things that people will do to avoid estate planning when they're not aware of the existence of a Ladybird deed. So let's start with joint tenants with full rights of survivorship. This form of ownership has pros and cons. It's a very, very binding form of ownership. What does it mean specifically? it means that two or more people own a property. And when one passes away, title vests in the survivor. So if there were three and one person passed away, title vests in the two. When one more passes away, title vests in the one. And someone might say, well, Rick, isn't that exactly what the ladybird deed does? You know, I'm here when I pass away, I want my kids to get it, they get it. And I'd say, well, yes. And it can work just like that. But we talked about earlier some unintended consequences. And what's important to know, and this goes with any version of a deed outside of a ladybird deed, if you're using it for the purpose of estate planning. So I want to put my kid on the deed because I want to make sure my kid gets it if I'm not here, and I want to avoid probate, which will be the second part of our discussion. Unintended consequences. If I use a different form of deed, so let's use the one that's in front of us, the joint tenants with full rights to survivorship, and my child has some type of problem. For instance, my child is driving under the influence and hurt somebody, and they sue. This is now an asset that my child owns. Now, in comparison to the ladybird deed, it is a contingent remainder interest, and I probably should have made this a little more clear. What does that mean, contingent? That means there is not a present ownership established in the property for my children. Why? Well, the ladybird deed makes it clear that it's contingent. Why do I want that as me, the property owner? Because I want to retain all the control unless I am no longer walking this planet. But until that time, I don't want to consult with my kids if I want to sell. I don't want to consult with my kids if I want to get a mortgage. I don't want to consult with them about anything. They're my kids. I love them, but I don't want them to be co-owners with me. And if you use another form of deed, that's effectively what you've created, a co-ownership situation. And these joint tenants, the joint tenants with full rights to survivorship, and I'm not trying to scare people off this form of ownership, but it is a very binding form of ownership. And the reason it's binding is that, we'll go back to my example, there's three property owners. One property owner wants to sell, two property owners want to sell, and one does not. There is no mechanism to force a sale. I want to be really clear about that. There is no court mechanism. There is no mechanism of any kind to force a sale. And people oftentimes don't appreciate that. We see this form of ownership used, for instance, in cohabitation. You know, a boyfriend, girlfriend buy a property together, and they own it in this form of ownership. This is more binding than a marriage. This is, generally speaking, a form of ownership I would only have people enter into after careful consideration. As the grantor of a ladybird deed, the person that owns the property, you identify the remainder. You can specify this form of ownership, and there could be good reasons to do it. What I would just counsel is that it should only be done after discussion with an attorney to understand the ramifications of it, to make sure that this form of ownership actually meets the requirements or the goals of the person completing the deed. Now, what we don't have in here is joint tenants. And joint tenants you don't see very often, but it is one of the forms of ownership in Michigan. Joint tenants is just like joint tenants with full rights to survivorship, but I would call it joint tenants with full rights to survivorship light. Why do I call it light? Well, because joint tenants creates a joint tenancy. And if one person dies, the other person gets it. So in our example of three, if two people pass away, the last person inherits the property. But if one of the three, while they're living, decides, you know what, I would like to sell the property. I don't want it anymore. This is not working out. I don't get along with the other two. Well, you don't even have to have a reason. I just want to sell. And you approach the others and they say, nah, we don't want to sell. You can take the co-owners to court, and the court will break this form of ownership by right. And that's a significant difference. So to be clear, in joint tenancy, if someone passes away, the remaining owners, they obtain ownership, specifically that 1/3 in my example. But anybody can break it at any time. compared to joint tenants with full rights of survivorship. It is unbreakable unless all parties agree, which is a very significant difference. Our next slide. Tenants in common, which we probably should start. We're gonna have to, I think, switch the order, Bunny, because tenants in common is the most common form of ownership. In fact, in Michigan, if a deed is silent, so if it says Rick Linnell and Bunny Lieberman own this property and nothing else, doesn't say joint tenants, doesn't say joint tenants with full rights of survivorship, doesn't say tenants by the entireties, it is tenants in common. So in Michigan, the default form of ownership is tenants in common. And tenants in common has benefits, potentially drawbacks, depending on the scenario. But tenants in common, each person owns an interest. So Bunny and I own a property together. I pass away. My heirs get my portion of the property. My ownership interest does not go to Bunny upon my passing. I can sell my interest in the property without Bunny's approval. I can, depending on the scenario, which most properties would fall in this category, if Bunny refuses to sell the whole property, so I can sell my interest, I don't need Bunny's approval. I want to sell the whole property because I say, well, Bunny, it's a house. How am I going to sell my interest? I mean, we live there together as roommates, but you know, no one really wants to buy my interest with you. They don't know you. I'm sure you don't want that. Let's sell. And Bunny says, yeah, I'm not selling. I can take Bunny to court and I can force the sale. The court will, in fact, enforce that. And I give these examples, by the way, of going to court. It's not because I'm trying to convince everyone to go to court, but why I bring it up is that A, you know, there's an absolute right with joint tenants and with tenants in common to break the form of ownership. More importantly, most people, even if they don't want to sell, realize they're going to be forced to sell, and it never actually goes to court. Our last form of ownership. Next slide. All right, skip one more. Tenants by the entireties. Tenants by the entireties is only available to married couples. And it provides significant benefits, specifically in the way of creditors. So if I sign a mortgage or not a mortgage, I sign an obligation and I default on that, my wife, who co-owns my house with me, is protected. Specifically, the entire household is protected against a creditor. This form of ownership can also be broken, which is the same as tenants in common and joint tenants, by divorce. That's a pretty extreme way to break it, but if you're getting divorced, the important part to know is you're not bound to each other. And so when I touched on earlier about joint tenants with full rights of survivorship being very binding, that is unbreakable except by mutual agreement. That even tenants by the entirety is breakable in a divorce. So the parties are not, I don't want to say handcuffed to each other, but they're not bound to each other in a way that is unbreakable. And we bring up these forms of ownership. I think it's always good to kind of talk about this. I'll give a quick anecdote. I had a unmarried couple. They asked us to write a cohabitation agreement. We talked about the forms of ownership. They decided that joint tenants was best for them. So that's the form of ownership where the survivor gets it. But if the couple, for some reason, were to decide not to be a couple, then that form of ownership could be broken and they would have their respective ownership interests retained. And I want to be clear, this title company, this was not Chris, this was not Jessica, this was another title company. And I didn't select them. It was someone that the clients had chosen to use. So they decided joint tenants and they called the title company and I was done. I wrote my agreement. And they called back and they said, Rick, in our notes, you told us joint tenancy, right? And I said, well, I gave you the forms of ownership. And after talking about it, that's the one that you thought would best suit your desires. And they said, yeah, that's what we wrote down. The title company said that doesn't exist. And I said, doesn't exist. I said, wait a minute, you joint tenancy, right? I said, that's what we told them. I said, well, okay, how about if I talk to them? So I called and the woman answered and she was very nice. And I said, this is the people I'm calling about. And they said that, they said that they advised you that they'd like to own the property and have the deed prepared as joint tenants. And the woman said, you mean joint tenants with floor rights of survivorship? And I said, no, I meant joint tenants. And she said, well, that's not a form of ownership that I'm aware of. And I said, well, it is one of the forms of ownership. And she said, well, let me get back to you. She called me back in about 15 minutes. She said, I talked to our underwriting counsel. She said, I've been in this business for 15 years. I didn't know that was a form of ownership. And I appreciate her honesty. And I would of course never say names, but my point is that people aren't always aware of the various forms of ownership. More importantly, the implications associated with each form of ownership. And so I think it's good to touch on that as part of Ladybird Deeds. And of course, if you are entering into a Ladybird deed, you can determine the form of ownership that you want the remaindermen to have. And if it's silent, if you decide, well, I don't really know, Rick, I'm not sure, goals can shift, change, I'm going to do nothing. Then it's tenants in common, which I don't want to say it's the freest form of ownership, because there are benefits to these other forms depending on the circumstances. But if you're unsure, I would keep it silent or add tenants in common. I don't know if we have questions, but it looks like I got to my limit because I got to leave time for probate.
All right,
Great.
Jess, why don't we go to slide 10? All right, we can go right here. So I've been working in probate for quite a long time, and these interesting times of ours have created certain situations that we'd kind of like to give you an overview on. For most of you who may be logged on, if you are realtors or you may be title people, when you find out that there's a property owner who is deceased, my first suggestion is that you go to your title company, you go to Chris, get informational title. That's going to set the roadmap for what you need to do to get to the closing table. Probate in Michigan is a legal process, as you can see on the screen, that may be required when someone dies. Probate gives the surviving family members authority with which to act on the assets of the property. So if you find out that the homeowner is deceased, and they were the only one on title, you have no one in that family has authority to sign your listing agreement. No one has authority to go to closing. That's where we come into play. So when we find out that there is a deceased homeowner, one of the things we want to determine is, did that person leave a surviving spouse? If they didn't leave a surviving spouse, did they leave children? These would be children of the deceased person. As many of you know, we have so many blended families now, we want to be very careful that we determine who the heirs are of that deceased person. We are going down their bloodline. If you go to number 12, one of the things that family members sometimes will say, if you find out that the homeowner is deceased, well, they left a will, and it says in here that I'm the executor. Well, that's great. A will is a wish list. A will is not the rule. So if they left a will, we need to open up probate, and it shortens the process in that the person who left a will determined in their wish list who they wanted to handle the last of their business. That's the executor or personal representative. So it's easy enough at that point because they have priority. We don't need a court hearing. All we need to do is prepare the documents, send the original will, copy of the death certificate. That is a relatively simple preparatory process. However, if they didn't leave a will, that's the next. Okay. If they didn't leave a will, we must determine, again, surviving spouse, children of the decedent, and then we need to work with the family to determine who is going to be the personal representative. The person who has highest priority is always the surviving spouse. And even if family members may disagree about that without a will, that person does have priority. If that person chooses not to, then we can go down the line of succession and the others would have to agree between them. So the process. When I usually speak with a family, I indicate to them that when we're preparing these documents, I'm going to tell you that 99% of the time, there's no court hearing involved. Absolutely not. We're going to prepare the applications. We're going to get a copy of the death certificate and the names and addresses of the surviving spouse, if there is one, the children, if there are children. If there was no spouse or children, we're going to move down into brothers and sisters, and we move down the bloodline that way.
Bonnie,
Yes.
Bonnie, I have a question. How do I know if I even need probate? Who tells me?
Well, the title company is going to tell you, based on their informational title, who holds title to that property. If the informational title comes back and says the decedent is the only one on title, you know you need probate, because no one has authority to act on their behalf until the court issues a document called letters of authority. So that's the determination.
So Bunny, are you telling me that if somebody gives me some context clues like, hey, my grandma passed away and she gave this house to me, that I should maybe go to my title company right away to find out, to make sure that is in fact in the name of the person who's telling me it's theirs, versus maybe in grandma's name and there's a will or no will or etc.?
Yes, I'm telling you to go to title first, get the informational title. They're going to tell you exactly who holds title. Just because grandson said, grandma said I could have the house, doesn't mean there was ever a deed recorded in that respect. And even if there was a will and it gave grandson the property in the will, it still has to go to probate in order for the personal representative to have authority to act on the wishes in the will and sign that property over and deed the property over.
So does the title company tell me all this? Do they say, yeah, you need probate, or no? In which case they say, no, I'm done. If they say yes, they tell me all the things I have to do, or what do I do if they tell me my client needs probate?
The title company will hopefully refer you over to us and we will take it from there. And I will have the conversation with the person and we'll talk about exactly what needs to be done, the timeline, the costs. We'll get a copy of the deed and we'll know that that asset belongs in the estate. We have to prepare an inventory and all of the things that go along with it. And this is, again, a very quick overview. But one of the things that Rick brought up that is complicating some of the probate things that we're doing is tenants in common. We are running into many situations, as Rick I know will agree, where the property was owned as tenants in common. One person dies, their 50% then belongs in the estate. The other 50% belongs to the other tenant in common. And many people don't understand this. Why do I have to go to probate when I had the property, we owned the property together? Well, together is a whole different thing. So we are running into situations where someone has signed a quitclaim deed for the property and it came out later that they actually owned the property as tenants in common and didn't have the right to do that. And now we have to double back and open up probate for that 50% and have it moved over. We are seeing that in a number of occasions. You may see couples who signed a deed as tenants in common, and then they, and again, as Rick says, they broke up or one party died and it complicates things. It doesn't mean it's not doable. It just it's a little more complicated.
Interject here that the title company often gets requests to prepare quitclaim deeds exactly in those scenarios where they want to add a child or a friend or what have you. And we don't do them because we want that person to get the advice of an attorney to be able to know and understand what will happen if someone passes away, or exactly the scenarios that you guys just described. So that's very important, especially as a real estate agent. You don't necessarily want to help someone just quitclaim deed a property into some other names because it may not fit what they're looking to do in the future. So that's really, really important. And I do have two quick questions. The first one is more toward the probate. What about the parents? Are they considered heirs to the property, and where do they fall in line?
Line of succession is surviving spouse, children, brothers and sisters, and if all else fails, parents.
Okay. And then the second question is more back to the Lady Bird deeds. If an individual has a living trust, is it best to quit claim the property into that trust, or do a Lady Bird deed?
So I would say a couple things about that. One, if you have a living trust, but you have not funded it, you may have heard that term before. A living trust does no good unless if it's funded. It would be like, and I think this is the best analogy for real estate. I have a rental home. I create an LLC to own the rental home, except I leave the deed in my personal name. Well, that company is worthless. It doesn't do me any good. And it's not quite a direct analogy, but it's pretty close with a living trust. If you create a living trust and you don't fund it by deeding the property into it, then when you pass away, it's owned in your name, which means you're still going to probate, or your heirs, better said, are still going to probate. Generally speaking, a ladybird deed is a trust substitute. It doesn't mean it's the proper substitute for every scenario, but my point being that you would have one or the other. You wouldn't have both.
I want to, in that regard, Rick, I'd like to bring up one other thing, because I think the title, another reason why we really prefer that in pre-title be run is that we get calls at the 11th hour when people find out that they thought the property was in the trust, and they have this fabulous trust book with 14 subdirectories, and it turns out that the property is sitting outside the trust and was never funded in. And those frantic phone calls come 48 hours before closing, because that property, perhaps the trustee of the trust is deceased, and that property is sitting outside the walls of the trust, and we have to turn around and open up probate because it isn't in there. And there's a lot of angst and a lot of unhappiness about that, but it does happen. So we want to let you know that. Also, if a property is in the trust, we can prepare the certificate of trust existence and authority, which is a review of the trust to certify that we've seen it, that we verified that the trust is valid in Michigan and that the property lies in there. This is something we do all the time. We can turn those around in a day. Those are not difficult. The harder problem is when people can't find the trust at all. And we have situations also. But we will take you through step by step, you or your clients, the probate process, explain it step by step. Now, in old times, normal times, we could sometimes get those estates open within a day once we had all of the documents signed. That doesn't happen now. I will tell you in general, from the time we submit an application for an estate to be opened to Wayne, Oakland, or Macomb, we're running about a 3-week turnaround in order to get letters of authority. Unless we've had in the last, 18 months, we've had one serious emergency, Rick, where we had to get a guardianship and a conservatorship opened like in a nanosecond. And Macomb did act within 24 hours. But the fact that somebody's coming to closing and at the last minute realizes that they need probate is not an emergency on the court's docket. So about a 3-week turnaround from submission. Out County, Lapeer, Genesee are running closer to maybe 10 days. They're pretty good about it. But these are things that we need to deal with. We know how to get them done, and we'll take your client's hand and walk them through it.
I do have a question. Just to be clear, if my attorney prepares a ladybird deed for my home, which I have owned for years, and I record the ladybird deed, the taxes do not become uncapped, correct?
That's correct. And the reason they don't become uncapped is because the current owner is still the owner. And that's why we talked a little bit about it earlier, and that is the remainder interest is contingent. So there is no transfer. Now, if it's your children, there's no uncapping anyways, but not everybody has children. Not everybody has children they want to leave property to. So it would be significant if you left it to a friend or an organization, that there would be an uncapping in some other form of deed. I want to be clear. But in a ladybird deed, because it's contingent, which means that organization, that person may never get that interest. There is no uncapping.
Great. I have another question. Is a property transfer affidavit required when recording a Lady Bird deed?
I recommend doing it. Is it really necessary? No, because the same address is going to get the tax bill, but as a technical matter, the answer is yes.
Thank you. So we are already past our time, but we are willing to stay on for a few minutes more. If anyone has any more questions, feel free to type them in, or you can go ahead and unmute yourself and shout out a question. I just want to thank everybody for coming today and joining us. We will be putting our notes and the video recording on our website. We will be sending an email to everyone with that link so that you can refer back to the recording and also to the notes afterward. I just appreciate Rick and Bunny, two of my favorite people, for joining us today and giving us this information. And again, if you'd like to stay on for a few minutes and ask questions, feel free to do so. Otherwise, we just really appreciate all of you attending today, and thank you very much.
Thank you, everyone. And we will stick around.
Thank you.
I had a quick question. This is Ted Easterly from Remax and Dearborn. A lot of times people prepare the trust and then they do a quitclaim deed to the trust but don't record it. Does the estate, or is that still recordable after the original trustee passes and it becomes an irrevocable trust?
Well, a couple things in there. First of all, Ted, when that deed's recorded, or when the original trustee of the trust passes away, it does not become irrevocable. It's a revocable trust. But I just want to be clear, that terminology is not quite accurate. But the intent is that, of course, or the intent is still followed. In other words, it's not as though someone can change it, but it doesn't become an irrevocable trust. It's still a revocable trust. If the deed is recorded after the person is deceased, that can be done. What I am concerned about, because that question comes up a lot, do I hold the deed or do I record the deed now? I think it's important to record the deed. I do not personally want an unrecorded deed out there, especially because it may be misplaced. If I want to put it in my trust, I put it in my trust. And there's no negative, there's no uncapping, if I deed property into my trust, I should let my homeowner's insurance carrier know. There should be no change in premium whatsoever. I should let my title insurance company know. I believe there's a rider that you pay for, but I think it's somewhat nominal. So I would let those things, I would alert those people or those parties to that. But to me, the idea of an unrecorded deed just presents a recipe for things not going the way I want. And more importantly, I don't see the negative in recording the deed. Now, again, that's limited to your example, Ted, of deeding my property into my trust.
It comes up a lot, and people have a lot of deeds that they're holding, and in some cases they don't have a trust. They're just holding a deed for 20 years. So the Ladybird would be an alternative that certainly makes a lot of sense too.
Well, as you might imagine, I agree, Ted. I mean, that, and you bring up, and I'm glad you brought it up, because other deeds like the joint tenants deed or joint tenants with forward to survivorship deed, well, that deed is live when you sign it. The fact that it's unrecorded doesn't mean it didn't happen. And so you have potential tax issues that could stem from that. You could have a child that you become estranged from, and they know about that deed, and they could take you to court on that deed. It could get lost. And the benefit of the Ladybird deed is you get to do all the things you want to do if you're not here. But if you're here, you have 100% control. And that's the big issue. I don't have to hope someone can find it. I don't have to hope my kid doesn't marry somebody who I don't like and they get divorced and they know about the private. All that goes out the window. None of those concerns that can happen to people, that happen in life, none of them have any relevance against my property if I'm using a Ladybird deed or a trust. I could use, and you just want to be clear, you can also use a trust, either or, but in many instances, people, the only asset that they have that they need to worry about for probate is oftentimes their house. And if that's the only asset that is a probate concern, then the Ladybird deed will oftentimes fulfill all the desires and wishes of the owner rather than a trust.
Thank you.
Welcome.
Thank you. Does anybody else have a question?
I have a quick question. Natalie Schultz, I'm an attorney. I do probate work. We've had some different language that we've used throughout time, like with wording on a deed for a ladybird. Is there a specific way that you prefer that when you draft a ladybird deed?
Yes, we, in fact, I'm okay with sharing that deed with you if you want to email me.
Great, that would be nice. Thank you.
Mhm.
And then I had one other question as a side note to what you were telling the previous person that asked a question. It was my understanding with revocable trust that when the settler dies, it becomes irrevocable.
Well,
Is that that was
I want to draw the distinction between an irrevocable trust and a revocable trust. So you are correct. I'm in these conversations. I never know who's there, so I never know how far the drill down is. But you are correct. The wishes of the trustee are irrevocable at that time. The trust is set because that person who created the trust passed away. So you are correct, Natalie. And Ted, if that's what you were saying, then I apologize. I didn't give you quite the right answer. So I appreciate that clarification.
Thank you.
Awesome. Thank you. Anybody else have questions? Okay, just one
You're gonna
last.
send this out afterwards, I take it, the presentation and stuff?
Yep. We're going to send out the presentation. We're also going to create a notes page that will go on the website that you'll be able to download and print out and use as you need. One other thing that I neglected to mention is that because we don't practice law, title companies don't practice law for other individuals, we do always refer to attorneys when someone is in need of a quitclaim deed or a probate or a trust. And because of my relationship with Rick and Bunny, they are two people that we refer a lot of business to have those deeds prepared. So if you have any questions, we again are happy to take those questions, and then we'll be able to refer you to the appropriate parties at that time. But just keep in mind, if you need something from them, they're happy to talk you through the process and then take care of those needs as you go along. So I just, again, want to thank everybody for joining us. If anybody else has another question, feel free to shout it out. Otherwise, we're going to sign off in just a minute here.
I would add, by the way, that thank you, Chris. We are happy to take questions. We charge, of course, that's how we make a living, but we don't charge people unless we tell them they're being charged and they agree. So the point of that is, you run into a situation, you want to run it by somebody, feel free to call our office. And this goes for all things real estate, from construction issues, land development issues, land use issues, easement issues, environmental issues, issues with Eagle. If it has to do with real estate, we do it. And we're happy to talk about it. And like I said, if we get to the point where we say, this is what we would charge you for this, you can, of course, end the conversation. And we're not offended in the least. We are happy to make ourselves a resource, just like Chris and Vanguard does. So feel free to call us if you run into an issue or your clients run into an issue. Feel free to pass our name along or to call and participate with them in a brief free consultation.
All right, great. Thank you everyone again for joining us. I hope you all have a wonderful day.